Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we are very lucky to have one of the most prominent construction attorneys in the state of Kansas, providing our webinar today on a contractor, subcontractor. Wow, we're going to have to, I've done 3,000 of these. Thank goodness we can edit those. A contractor, subcontractors, and suppliers step-by-step guide to getting paid. Leslie is absolutely extraordinary. She took a case all the way to the Supreme Court and created law. In addition, she is an absolute guru on construction lien law. So without further ado, I'd like to introduce Leslie Bowe.
Thank you so much. I'm Leslie Bowe. I've been practicing construction law for 22 years now, and I'm pleased to be here today to talk to you all about steps you can take to make sure that you are going to get paid for your work and materials furnished on projects in Kansas. So just a little webinar info. If you have questions as we move along, please throw them in the chat, and we will answer questions at the end. And happy to take up any questions you have, so please share those. Just a brief overview of what I'm planning to touch on today are these steps you can take to ensure your ability to collect the amounts due to you. So on the front end, before you even step onto the project site, we'll talk a little bit about negotiating and understanding your contract. We will talk about ways to bargain for and use effective dispute resolution to ensure your ability to get paid. We'll also talk about a really important aspect of pre-work, pre-project tasks that you'll want to complete, which is investigating and obtaining adequate assurance of payment before you even start your work. Once your project is underway, you may, if you've ever talked to a lawyer, we've probably preached on this to you, but document, document, document. It is key to being able to prosecute a claim down the road that you have adequate documentation to support your claim, as well as documentation to defend against any opposition to your claim or potentially someone trying to reduce your claim amount. And then again, while you are working, if we're getting hints about problems with getting payment, if payment is being slow or you're not getting paid at all, it's really important to know when you can suspend your work, what rights you have around that, and preserving and using your mechanics lien and bond rights. We won't go into all the details of those today because there are other webinars that, you know, we could spend a day talking about that, but we will touch on some key elements that are important to know right off the bat as far as preserving those claims for you. And then also preserving claims against your downstream subcontractors and suppliers. So that's what I'm planning to touch on today, and we will jump right in. So key contract terms that can impact your ability to get paid. And, you know, in truth, every single word in your contract somehow relates back to your ability to get paid. But these are key contract terms that we see litigated quite a bit. When we're trying to get a client paid, these are things that will come into play. And this top one here is scope of work. So it's very important that your scope of work is clearly defined within the contract. If you have put together a detailed scope of work in your estimate or proposal or your bid, we always recommend that that be replicated within the contract or at least incorporated by reference. And one key item for clients to remember is that your scope of work not only includes what you are going to do, but any exclusions that you need to make of things that are not included in your price. So this gets litigated all the time, whether or not something was truly within the scope of work or whether you're entitled to extra compensation for that work. Which leads us right into the next key contract term that can impact your ability to get paid, and that's change order procedures. So it's very important for both you and your project team to understand what is required of you in order to get paid for extra work. So it's important to understand what kind of notice you have to give when you've encountered change conditions. It's also important to understand what's required to get compensated. If you have to have a formal executed change order, you need to have that before you start work, no matter how much pressure somebody's putting on you to get out there and get it done, because you know that's the way these things work. There's always a lot of pressure to get started, but if you need a formal written change order, you've got to get that back first. And probably where we see the most litigation is where there's just some sort of a requirement of the contract that it be in writing. And so, oh, well, we've got these emails or we've got texts where they told us to go move forward. And what we always counsel clients around that is you really want those to be as detailed as possible. So if you get something vague back from either the owner if you're a GC or GC if you're a sub, you were going to want to respond in writing, confirm your understanding of the agreement, exactly what's going to be done, what the price is, if you're doing on a time and material basis, what those rates are, or if it's a lump sum, what amount you've agreed to. That way we've got a good something in writing to look back on down the road to prove up that you've met the contract requirements to get compensated for your work. Other key terms that tend to impact the ability to get paid that we see litigated quite a bit are notice requirements. So how much time do you have to give notice under your contract, how you have to deliver your notice under your contract, and who you have to give it to. So, you know, as you can imagine, it comes up all the time that, oh, well, I sent this guy who was my main contact, you know, 2 years into the project, we've got a new guy who's your contact. Well, we still have to follow the contract. Otherwise, technically, they've got a defense to your claim. So always go back to the contract and follow those terms exactly. The last two, I actually have separate slides on that we'll go into a little bit throughout here, but pay if paid and pay when paid clauses, obviously very important in terms of your right to get paid. So Kansas recognizes a difference that's recognized by most courts now, that a pay if paid clause does actually set a condition precedent to your receiving payment, and it will require that your upstream contractor or owner, if you're a GC, your upstream contractor has received payment from the GC or the owner before they are actually required to give a payment to you. And that's enforceable in Kansas. Pay when paid clauses are looked at by Kansas courts as those that just set a reasonable time for payment. And those have impacts on that we'll talk about a little bit later on when you may be able to suspend your work. And then finally, dispute resolution clauses. I mentioned, so I'll go ahead and skip to the next slide on this. So we recommend that you bargain for and use effective dispute resolution clauses to help you get payment and get payment quickly. We've got two kinds: non-binding dispute resolution and binding dispute resolution. So most contracts are going to see a binding dispute resolution clause, especially in the construction industry. We see arbitration used quite a bit. But we like to see non-binding dispute resolution clauses included. And we do see them more and more nowadays on very complex and large projects. You may see all three of these types. And on smaller contracts, you may only see one. But we've got direct negotiations between decision makers. So, you know, basically the contract clause will say something like everybody's going to make a good faith effort to meet and try to sort out our differences. It may have a provision providing for an initial decision maker, like an architect, who will make decisions on whether a change order is appropriate or not, or any other type of dispute. And then mediation. So mediation can be required prior to initiating any kind of a dispute resolution that's binding. And we like to see that used because, as you probably know, on construction projects, it can often be important to get disputes resolved very quickly. So we don't want to get into a big fight where we're now suspending performance and holding up the project, and we're worried about incurring delays. We'd like to see some type of a resolution reached quickly so that everyone can move forward with the project and continue to do what you all do best, as opposed to get sucked into litigation. As far as arbitration versus litigation, we like to see arbitration in construction contracts because in a lot of cases it can be really important to have an industry expert or somebody with industry knowledge deciding your dispute, as opposed to a judge who hears all kinds of cases day in and day out. It can be important in certain, especially in certain types of construction disputes, to have somebody with industry knowledge deciding your case for you. Tips for contractors. So I hinted at it earlier already, but we like to see mediation as a condition precedent prior to initiating arbitration or litigation. I already talked about this. Final thought, of course, we want to see your contract clauses providing that you can get your attorney's fees if you have to utilize any of the dispute resolution methods to enforce your rights under the contract. Moving on to investigating and obtaining assurance of payment. So before, this is optimal to happen before you start work, but sometimes it needs to be revisited when maybe extra work is requested, when there's a change in scope or direction of the project, or the cost of work increases for some reason. So you guys are out there working on a project basically on credit. So it's always your business, and you're entitled to know if the owner can pay for the work. I know sometimes you get pushback on this, but it is something that is really important, especially before you get into deep on a project. And I've seen subcontractors bring up a general contractor's failure to do their due diligence to make sure the owner can pay as defenses to, maybe a pay if paid clause. I haven't seen that prosecuted successfully, but I've seen people argue it. So just one thing to note, commonly used construction contract forms, both the AIA and consensus docs contemplate owners providing their information on financial project information showing that they will be able to finance the project. I note here the AIA only requires it prior to execution, but then you have to have a reason to get the information later, for example, a missed payment. Consensus docs provides for providing that information throughout. I see pushback on that. Owners tend to prefer a clause more like the AIA, but these are all things that can be negotiated. And then obviously you want to follow up and actually do it. If you have the right to do it in your contract and demand that financial information, follow through and make sure you get that done. So a tip for contractors is to condition your bid on the approval of the owner's credit. This sample clause right here not only says it's conditioned on that, but also requires that, this is for a subcontractor, that they be provided with the legal description, address, project owner representative. That's going to help them if they do need to file a lien down the road. And also requires that they be notified of material changes. So, if they get bought out, or something happens and they can't continue the project and they're looking for another owner to come in and take over and buy them out, these are things that a subcontractor under contract you want to be notified of. All right, tips for suppliers would be a little different. Obviously, suppliers sometimes know very little about what's actually going on a project. We always recommend our supplier clients educate their salespeople so that we do know where their material's going, and as much as we can find out about the identity of the key players on the project, who the general contractor is and whatnot. Kansas is very picky. You have to establish your place in the contractual chain and properly name all of the, the general contractor and the subcontractor, tying you all the way up to the owner in order to have a good lien claim. So it's very important to collect that information on the front end. We always recommend our suppliers use contracts as well. So a very thorough credit application that contains your terms and conditions of sale. And we also recommend getting a personal guarantee so that in the event it's necessary, we do have the ability to go back and hold an owner personally responsible for the company's debts. And then I always tell people, don't just have them fill it out, but you have to follow up on it. So when you get that credit application back, call those references, check with their bank and make sure they're still actively banking there, so that you do have that information to provide to, hopefully you don't ever have to call a lawyer to get your money paid, but you do have the information to do so if it becomes necessary. Once you are on a project and you've done what you can on the front end to protect yourself and your right to get paid, it's important to continue up the due diligence and document your work on the project. So documentation is always best if it's standardized company-wide with consistent internal practices and forms. This is just good business practice, of course, but it's also important for when something's not there. So if we need to be able to say, hey, if we don't have a document showing this, it's because it didn't happen. We have to be able to, someone has to be able to testify in court that if it happened, we would have this form. So it's very important to have and educate your staff on the expectations of what you want documented on a project, all the information that should be included. And one of the best ways to do that is to give them a form to fill out so that they aren't trying to remember what all they need to be documenting. Good documentation will help establish the cause of events. It helps preserve and reserve your rights, and it helps identify actual costs and delays. And finally, it has to be contemporaneous. It's not useful to have your project manager or superintendent sit down at the end of the month and try to go back through his texts or his emails and his calendar to try to reconstruct what happened that month on the project. In order to be reliable and actually used as evidence in court, we have to be able to show that these documents were maintained contemporaneously. And, memories fail, and one day can run into another on a project, and there's absolutely no way that, 2 years down the road, somebody's going to remember the difference between one day to another, unless there was a significant event, which usually is a bad thing. We don't want those. Try to move along a little quicker here. So daily reports are the backbone of project documentation. One key thing I want to point out here is that you do need to record delays, inefficiencies, call out other subs that are materially affecting your work, and keep doing it every day that your company experiences these. So don't just mention it the first time it happens and then, don't say anything about it again. Keep repeating it. And when you get pushback from anybody higher up saying they don't like how you're doing your dailies, those are the same people that are going to, turn around 2 years later and not pay you if you didn't document your claims properly. So continue to do that in your daily reports. So documentation with the e-doc email and text and all the electronic communication we do today, it really has changed how we do business. And what we see in my world is that it tends to feel more casual. So one thing I'm always counseling clients on is, even if you're not typing out a formal letter that's going to go in the mail, do keep your communications professional. But also keep in mind when it might be useful to put an actual letter in the mail or on the fax machine. So you do want to keep your documentation appropriate, professional. And one key thing that helps is keeping the content of your communications limited to one project or one item. Sorting through email chains can be a nightmare when we're talking about multiple projects, what applies to what. So it's helpful if you can keep it to one topic. And always watch out for attorney-client privilege issues. We see problems with this because of email. So things get forwarded around internally and then it goes out and someone's forgotten that the lawyer's advice was, 10 emails down in the chain. All right, so when you are getting hints of that payment may be not forthcoming, or if you're actually not getting paid, things to keep in mind and steps you can take to protect your right to get paid is being aware of your right to suspend work for non-payment. So as a lawyer, when I get a call from a client saying, hey, can I stop work on this? It's always a bit of a scary proposition, because when you are not working, and if you're not on the job, then you lose a lot of control. But the ability to suspend your work is a very powerful tool to light a fire. So your pay in your contract, if you don't have an actual clause that outlines your ability to suspend work, know that if you are following a pay when paid clause, you can have a basis to suspend work, because that clause is read to only limit their ability to hold off on payment for a reasonable amount of time. However, if you have a pay if paid clause, that is a risk shifting clause that put all risk of non-payment on the lower subcontractor. So you do have more of a risk in suspending or terminating your work for non-payment in that type of a situation. Under both the Kansas Fairness and Public Construction Contract Act and Private Construction Contract Act, you do have a statutory right to suspend payment. There's notice required. So if your payment is 7 days late and you give another 7 days notice, then you can suspend payment. We use these all the time for those threatening notice letters. You know, here's the problem. We are invoking our rights here. Whether you actually stop work, I always would recommend you talk to a lawyer first, because there can be risk involved with that. So, but do be aware of your rights, because if you know what your rights are, then you can communicate with the higher ups in the contractual chain with knowledge and put them on notice that you know what your rights are. Further, with regard to non-payment, it's very important to preserve and use your mechanics lien and bond rights. They're very powerful tools to get you paid, but they are very time sensitive. So running through those deadlines there. In Kansas, you've got 3 months for a subcontractor and 4 months for a general contractor to file a lien. On commercial projects, you can extend that to 5 months for both, but you have to have filed your notice of extension with the district court where the project is within that original deadline. So we recommend all clients keep those tickers and red flags in your systems for 3 months and 4 months so that you can preserve your rights there. Bond deadlines on federal projects, it's going to kick in. You have to give notice within 90 days of your last day worked. State projects and private projects, there's no notice requirements by statute, but you need to review the bond. And then preserving your claims against downstream subcontractors and suppliers. I've got an actual slide on it, but it's important because you want, if you do get dinged from higher up, you want to be able to take that, carry that cost down to whoever may have actually caused the, delay or defective work or whatever it was underneath you. So tips for contractors here, get a copy of the payment and performance bonds early on when the project starts. Review that language and know the applicable time deadlines. And it's important that not only the owner of the company know this, but the boots on the ground know it, so they know when they need to get the back office involved and start giving out notices. Also be aware that you're not waiving any rights by signing two broad lien waivers or bond waivers. And we actually have a whole seminar about the types of waivers, so I won't get into the details there, but you do have to follow all of the requirements and notices in making your bond claim. So it's very important to understand how that works. And then sort of preserving your claims against downstream subs. Of course, it's always important to do business with reputable and financially sound subs and suppliers. So on the front end, like we talked about, making sure the people above you can get paid, it's also important to understand where they sit and that they're able to take care of their own suppliers and their own bills. Always, we recommend you enter into written contracts or purchase orders with your subs and suppliers and use flow down clauses so that your contractual obligations to the higher ups, whether it's a general or an owner, also carry down to your subs and suppliers. And I think that's it. I just went over a little bit, but do we have any questions in the chat?
So far, we do not have any questions. You did such an incredible job. In fact, one of the remarks was, you did such a great job by one of the attendees.
Well, good. Hopefully I didn't talk too fast. So I was concerned about getting through all the material because I could talk about these. What we do day in and day out. Of course, I always have some, construction defect cases going and that kind of thing. But a large part of what I do is trying to get my clients paid. So I could talk about these issues all day.
Yes, and you really did such a great job. Thank you. And if anyone does have any questions, Leslie's email is in this webinar. You can see that at the bottom. And that's it. So I think we have a few more slides we'll go over with everyone. So, our next webinar is coming up.
See if I can flip that.
If you want to take a brief moment, you can actually put a Google review. If you want to take your mobile phone and point it at that QR code, we'll put that up there for just a minute. It would be great if you could give us a review on our webinar.
So it looks like upcoming, we've got what happens after I record my lien? How do I get paid? And don't sign a waiver or release without reading it. So obviously, some of the things we touched on today, there's a lot more information in those. So I would encourage everybody to have a look at SunRay's webpage with all of the options you have. You've got a great resource there to educate, your whole staff as to protecting your right to get paid and take advantage of what they're offering there.
Thank you so much, Leslie. And you once again did such a sensational job. And I would like to wish everyone a sunny day.
Thank you.